Okay, we are on the record. This is the people of the state of Michigan versus George Andrew Hill Jr., case 2256209. Mr. Hill Jr. is charged with 1 count of malicious destruction of a building, $1,000 or more, but less than $20,000, with the habitual offender second offense notice dated except for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Robert Cantor, P24993, appearing on behalf of George Hill, who I believe is present via Zoom.
Mr. Hill, can you state your full name for the record, please?
George Andrew Hill Jr.
Thank you, good morning. Any discovery issues?
Yes, Your Honor. I have not received any discovery at all to date, so I would request that again and ask for an adjourned PCC date.
Mr. Kirker?
I was not the one who was handling the discovery yesterday. If I remember correctly, I think we were in the process of getting discovery for this case.
Okay, how much time do you think we needed? Or Mr. Cantor?
I'm sorry, Your Honor. What did you say?
For an adjournment, I'm asking Mr. Kirker because he actually would know better, I guess. That's the one
Okay.
just be provided. Maybe.
I know the officer in charge and supervisor were emailed yesterday to recreate the file for this case.
Okay. So how about a week out?
That's a bad day for me, Your Honor. Could we do 2 weeks out?
That's a lot of time. Let's see. You have anything next week?
I'm looking. I don't have any dates next week.
Okay. It'll just be a PCC at 8:30. Won't.
Right. I could possibly do March the 2nd, actually Thursday, next Thursday.
Okay, I'll make sure I'm on it at 8:30. You can call first.
Okay, very good.
All right. Hopefully you'll have discovery by then.
Right. Thank you very much, Your Honor.
You're welcome. Have a good day.
You too.
Am I all done?
Good morning.
1 second, Attorney Jefferson. Mr. Hill,
Yes, ma'am.
you're all set. So we're coming back
Thank
next
you,
week. On March 2nd, you can call back on Zoom again at 8:30, so we can get your discovery issues resolved, okay?
Yes, ma'am. Thank you. Have a wonderful day.
As well, thank you.
Thank you.
Attorney Waldorf,
Yes,
are you ready on your case?
excuse me?
Are you ready on your case?
Well, this is the third time for a PCC. There were 2 failures to appear in the past. I'm not sure what to say. I did try call him yesterday. A voicemail announced him by first name, and here we are.
Okay. All right, let me call it. This is case number 2056610, the people of the state of Michigan versus Lamar Eugene Williams. Mr. Williams is charged with count 1, stolen property, receiving and concealing a motor vehicle, second or subsequent offense notice Count two, motor vehicle unlawful driving away with a habitual offender fourth offense notice. Today is the next step for a probable cause conference appearance.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Kenneth Waldhorn, P37819, on behalf of Mr. Lamar Williams. I don't know if I need to repeat what I've just indicated to the court, but to be perfectly honest, I don't think he's going to appear.
Okay. All right, and this is the first time I've had this case. I see a case from November 28th of last year. This case has been going on for a minute. Okay. So I will issue a case today. It'll be a personal 1,000, and we'll go from there.
Thank you.
All right, have a good day.
You too.
Okay, Attorney Jefferson, good morning.
Good morning, Your Honor. I got
How you
Lamar. I'm trying to keep more of my powers out, but other than that,
Other than that, you're good.
I'm lucky to be, I'm thankful to be alive, put it like that.
Right, we can start there.
So I have Lamar Jordan.
Okay. All right, let me fill out this form and I'll call you back. We are on the record. This is people of the state of Michigan versus Lamar Jordan, case 2355528. Mr. Jordan is charged with count 1, robbery armed. And that is it. Mr. Jordan is defendant number 1 on this case. Today, the next step for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Thomas St. Jefferson on behalf of Lamar Jordan. And I don't believe Mr. Jordan is here. I am asked that I am still seeking discovery, and I am asking this matter be set for a live exam. Thank you.
Okay, have you been in contact with Mr. Jordan?
I have reached out to Mr. Jordan, didn't make actual contact, but I do have an investigator that I am going to have go and find Mr. Jordan.
Okay. Okay, Mr. Carter, regarding the discovery.
No, other than just clarifying, is it paper or digital or both? That are
Both.
needed? Both.
Whoa.
All right, I have March 6th open at 10 o'clock.
Let me see that. Let me take a look.
And then any day after that is pretty flexible.
Can we do? Okay, can we do it in the afternoon or I mean later in the morning, like 11 or 11:30? Or March 9th after 10?
Let's see, March 9th, because we have PCC. Let's just do March, can you do 11:30 on March 6th?
Yes,
Okay, let's do that. Anything else?
that's it, Judge. Thank you so much. Have a good weekend.
All right, you stay safe out there.
Okay, thanks.
DeAndre Wilson.
Yes, ma'am.
Morning. Sorry, what are you here for today?
I got a grand larceny case or a
Wow.
larceny from a building case.
It's at 11 o'clock. Did you know that?
Oh, it's at 11. No, I didn't know that. Thank you.
Wait, also, today is your exam. It should be in person unless your attorney told you to Zoom in.
Yeah, my attorney told me it was on Zoom.
So actually, we're gonna call your attorney to make sure. The only way we do it on Zoom is if you're waiving. I don't want you to tell me if you're waiving or not, but if you're not waiving your exam, you need to be in person.
All right.
So I'll call, you stay on here, let me talk to your attorney to make this clarification.
All right.
It's no. Well, actually, I don't have a copy. We're on the record as the people of the state of Michigan versus Dicuria Newell Thompson, case number 2260891. Ms. Thompson is charged with 1 count of assault with a dangerous weapon. This assault today is set for a written examination. Appearances.
Alexander Kirker on behalf of the people, 86282.
And good morning, Your Honor. Good morning, Madam Clerk, Madam Court. Jonathan Roberts, P 86428, on behalf of Ms. Newell Thompson. Ms. Newell Thompson, could you please state your name for the court?
Dicuria Newell Thompson. Good morning, everybody. Are both parties ready to proceed?
People are not, Your Honor. Subpoenas were sent out in this case, and we have no indications of why witnesses are not here.
Okay, do you think that's,
On that basis, Your Honor, we would move to dismiss without prejudice today.
okay, time is 9:05, this exam is set for 8:45. Complaining witnesses are not present, I will dismiss without prejudice. Anybody else?
That's all from the defense, Your Honor.
Okay, Robert record. Okay, that's fine. That was a lot faster than me. So Robert, you had a busy day today.
Yes. So I do apologize for holding your courtroom up. I do just have to go to Judge Robbins.
You're not holding anything up. You're fine.
You got this one.
You're ready.
I'll be
You got this one.
Okay, let's handle Mr. Anthony Williams.
Yeah.
Wait, Mr. Williams.
This is the people of the state of Michigan versus Anthony Williams, case 2355533. Mr. Williams is charged with 1 count of controlled substance, delivery, manufacture of marijuana. Today is the day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P 86282.
And good morning, Your Honor. Steve Mencken, P 31562, appearing on behalf of Anthony Williams.
Mr. Williams, can you state your full name for the record, please?
Anthony Lorraine Williams.
Good morning to you.
Good morning.
All right, any discovery issues?
Your Honor, I did receive the written discovery and I just checked. I talked to my client. I didn't realize I have video discovery also. The only thing is, originally I was given a phone number that had the last second to last digit was wrong, and I sent my client a letter, and the first contact I had with him was this morning. So what I would ask is maybe one gentleman to make sure I discuss everything with him to verify how he proceeds. I did talk to him for a little while, but I want him to be able to get, I'm going to send him a copy of the written and the video so he can look at it and decide how we want to proceed.
Okay, so do you want to set an exam date out further with the PCC or what? I should ask you, what do you want to do?
Well, why don't we just set the PCC first, because we'll make a decision whether we're going to hold it or not, because otherwise they have to send out subpoena for witnesses. So I'll see if it's necessary or not.
Okay, so how much time do you need to consult with your client?
Just let me see. I guess it depends on my schedule. I don't need a long time. Let me take a look. Let me see. The only thing is I got trials. Let's see. Let's see what I can see. What about could I put it to March 6th?
That's fine. We do 8:30 again.
March 6th at 8:30? Okay.
And it'll be on Zoom, Mr. Williams.
Okay.
Thank you, Your Honor. And just ask Bond to continue.
Bond is continued. You have a good day.
You
Okay.
too. Thank you.
Okay, to the gentleman who is in Division 2, can you state your name, please? In the Wayne County Jail? Yeah.
Lamar Devon Jordan.
Mr. Jordan. Okay, your attorney just called or zoomed in. She did not know that you were in custody. She's been looking for you. Have you talked to her at all?
No, ma'am.
Okay, so you're in Division 2. I'm going to have the clerk call her to make sure she comes and visits you because she didn't know, she thought you were out of custody.
Okay.
So let me give you your next date so you at least know that, but she's gonna have to come visit you. We're gonna call her, actually, I'm gonna have her log back on now. Just hold tight, I'm gonna have her log back on so you all can talk.
Okay.
Is that 3623? 840. Said he gonna step right in. Which one's locked up? We got locked one. So two. Just me.
Oh, okay.
please do not leave that room until you speak to an attorney.
Yes, sir. Is she?
Yes, she is.
Attorney Jefferson, do you need to speak to your client?
Yes. Yes, please.
Okay, I'm gonna put you on the breakout room.
Okay, thank you.
Mr. Jordan, you may have to hit join on your screen. I'm not sure how it works over there, but you'll get an invitation to a breakout room in about 5 seconds.
Okay.
So you sent the email yesterday?
I think I sent it maybe the end of last week.
Oh, in a timely manner.
I did send it just to the court.
And actually, I do have access to it.
Okay, so can we just leave?
What do we have set here? Yeah, we have a date set. So yep, you're all set.
Okay, thank you. Thank you so much.
You're welcome.
Madam Clerk?
1 second.
Oh, I'm sorry.
Mr. Jordan, can you hear me?
Yes.
Okay, so you have your date for March 6th at 11:30. We'll have a written set so that you can be in person for your exam, okay?
Okay.
All right, so you're all good. You're good for today. We'll see you on March 6th.
Okay, thank you. I appreciate it.
You're welcome. Have a good day.
You as well. Thank you.
You're welcome.
Good morning, Judge.
No, it is Judge Sabree. Her Zoom number is.
Good morning, Attorney Collins. You have William Frank. Are you ready to go on the record?
Yes, Judge, I haven't been able to contact him.
Okay.
I believe he's out on a personal bond, if the court knows that to be true.
Let me grab his file.
Okay,
One moment.
thank you.
I didn't catch that, I'm sorry. He's the co-defendant, so it'll be Jeremiah Bennett and Frank Williams. Okay. No, it's not. Look for Williams. Oh, wait, that may be one. I'm sorry. Okay. Oh, got it. Ah, okay. Okay, we're on the record as the people of the state of Michigan versus William Frank, case number 2355528. Mr. Frank is defendant number 2 on this case and charged with count 1, robbery armed, count 2, weapons funding firearm, count 3, weapons firearms possession by a felon with an habitual offender second offense notice. Today's date set for a public cause conference appearances.
Alexander Griffin on behalf of the people, P86282.
And good morning, Your Honor. Harold Collins, P56805, on behalf of Mr. William Frank, who is not present in the courtroom nor on Zoom at this time, Your Honor.
Okay, and I just realized that was Mr. Jordan who just logged off. I didn't realize it's a co-defendant case, and that was a co-defendant.
Oh, yeah, I didn't know that either.
Okay, let's see. So his bond was lowered to 50,000, 10%. I don't know if he was, or if he bonded out based off of that adjustment or not, but we don't have him in custody, do we?
No, Your Honor.
He's not in custody.
Judge, I know the jail roster says electronic monitoring unit.
Okay. And you have attempted to contact your client?
I have, Judge. There was an email address as well as a phone number where I've been leaving voicemails and tried to email him as well. So I'll have to defer to the court at this point. I'd like an opportunity to try to reach him, but it'll be at the court's discretion whether we have to issue KPS on him or something. He's a very young man. I do know that. So I don't know what to say.
Anything from the people?
Nothing from the people.
Attorney, since we have a March 6th date set for the exam, at 11:30, what I'll do is I'll adjourn this PCC. Today's the 24th. I'll adjourn this to, does the second work for you?
Judge, I'll make it work if you're willing to do that. Yes.
Yes, we could do 8:30, be the first thing in the morning.
March the 2nd.
Yes.
Okay, Judge, is that the exam date for the co-defendant?
No, we just have the co-defendant set for March 6th at 11:30.
Okay, Judge, and just for my help, if you will, the attorney who was representing that co-defendant, who was that?
That was Thomasine Jefferson.
Oh, okay. I'll reach out to her. Maybe I can find my client that way.
Okay, does that date work in the event that you do find your client March 6th at 11:30?
Let me check right now, Judge.
Okay.
Okay, March 2nd and then
March 6th.
and March 6th. Yeah, I can make both of those dates work, Judge.
Okay, we just need to find your client.
Okay, thank you.
You're welcome. I will see you on the second.
Okay, thank you. Have a good day.
You too.
All right. Bye.
Attorney Goldfarb, good morning.
I'm here. I'm Patrick Smith. It's for a PCC coming out of Judge Robbins' court. I've spoken to him. I believe, in fact, I just sent him an email that he is supposed to be the judge in this court, as opposed to Judge Robbins. I believe he had signed in there. If the court, we're going to be setting this up for an in-person exam.
Do you want me to check to see if he's in Judge Robbins' courtroom?
I just sent him another email with the correct.
I'm off mute.
No, you're hear you.
Oh yeah, y'all got me blocked in this camera thing.
Okay, is this Patrick, Mr. Smith?
Huh?
Mr. Smith, there we go. Thank you. That answers that question, Your Honor.
Well, I did that, so I don't know if it's actually him. What's your name, sir?
Patrick Smith.
That's Patrick Smith, Your Honor. Thank you.
In your video. We didn't block you, Mr. Smith.
All right, appreciate it.
Okay, let me call the case. It's the people of the state of Michigan versus Patrick Devon Smith, 2355321. Mr. Smith is charged with 1 count of weapons carrying concealed, set for a probable cause conference today. Appearances?
Alexander Kirkcraft, the people, P86282.
I'm sorry, could you please repeat your name, sir?
Alexander Kirkcraft.
Oh, okay, thank you. John Goldpaw, P30758, on behalf of Mr. Smith. Mr. Smith, would you please put your name on the record?
Patrick Smith.
Okay, discovery issues.
No, Your Honor, we've received the paper discovery, and I have also been provided with the digital discovery that was available. If there's more, we'll have to ask for that. But we've asked this be set for an in-person exam. Is that correct, Mr. Smith?
Yes, sir, that's correct.
Okay, the earliest date I have is March 6th.
May I check my calendar, Your Honor?
Sure. So March 6th, I only have 10 o'clock, but after March 6th, it's pretty open.
Okay. If I may, Your Honor, let's need a second to get on my calendar because I'm inept.
That's fine, take your time. It's 11:30. We'll get there. Thanks.
Are we ready? Who you got ready? Like, Mr. Roberts came. Oh, they are here? Okay. So, yeah, Mr. Robertson, you also have a cake.
Your Honor?
Yes.
Could that be moved to March 9th?
Yes.
Thank you.
I have 9:30, or 11 o'clock.
11 o'clock, Your Honor, I have an in-person hearing over in front of Judge Blonde.
Okay.
Thank you.
All right. So, Mr. Smith, that'll be in person at 36th District Court, March 9th at 11 a.m. Okay.
Yes, ma'am.
All right. You have a good day.
Thank you, Your Honor. Oh, and Mr. Smith, I'll be in touch with you.
All right.
Yeah.
Okay.
Good morning, Your Honor. This is Attorney Phyllis Dayton Robinson. I have Mr. Moore and Mr. Miles this morning. I had
Yeah, let me go check them.
Yep.
And talk to the hospital.
Attorney Roberts, do you have, is Mr. Hill with you or out in the hallway?
I believe Mr. Hill's in custody.
Oh, I see it. Okay. So Attorney Roberts, you might be waiting a moment since he's in custody.
That's fine, Judge. Would you prefer that I go back in and we handle the Nickerson matter first?
Yeah, but because we can't control the county jail calls in.
Okay.
Sorry about that.
No, thank you.
That was for who? Mhm.
Was that on the docket?
Robert who? Robert. Oh, he is on there. What? You said he? Yeah, Robert who? He should be the first page. Oh. Motion on this.
Oh my God, that was fast. I need to see. Wait, what case are you doing?
For Mr. Nickerson.
All I did was put the password. I'm trying to see on the tape page. Okay. So, January.
Yes.
That makes it easier. Okay.
He's not present.
Okay, just to make sure he wasn't accepted. Okay, everything, all right, this is case 2055147. People of the state of Michigan versus Richard Lee Nickerson. Mr. Nickerson is charged with 1 count of stolen property, receiving and concealing a motor vehicle with habitual offender. Third offense notice today's date set for a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor, Court Staff Jonathan Roberts, P86428 on behalf of Mr. Nickerson. Mr. Nickerson is not presently in the courtroom.
Okay, and Attorney Roberts, you have attempted, I'm sure, to contact your client.
Yes, I would just ask, Your Honor, that before the case be issued, we just be given one more opportunity to send some letters to his household to see if there is a way to contact. I will obviously leave that to the court's discretion.
Anything from the people?
Your Honor, I would ask for a KPS just because of the last time we were here. The 13, the defendant also did not show up.
And then on May 10th of 2021, case is well. So I am going to issue a case, it'll be a personal $1,000.
Yes, Your Honor.
And once you from there. Anything else on the record?
That's all from defense, Your Honor. Thank you.
Okay. So you just have blank left over, right?
Yes.
Okay.
No, they didn't show us.
Make some more copies of my papers for today. I don't know what's going on. Okay, we're on the record as the people of the state of Michigan versus Antonio Miller, case 2355278. Mr. Miller is charged with one count of controlled substance possession of narcotic or cocaine less than 25 grams. Please accept for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P 86282.
Morning, Your Honor. Please call Daniel Reed, number 30965. Here on behalf of Mr. Miller.
Okay, and I don't see Mr. Miller here, is that correct?
That's great, Johnny. We called out in the hall, we made phone calls. Then I do diligence, but not been able to locate Mr. Miller.
Anything from the people?
The people would ask for KP.
Okay. Attorney Reed, you did what you could,
Yes, sir.
so I will issue of case is, it'll be $1,000 person.
Thank you. We appreciate it, but we find it, we'll bring him in.
Okay.
Have a good day, everybody. Have a nice day. Be safe.
Call my left and my feet.
I know that's right.
Hello again. I feel like I'm seeing you at least twice a week now. Okay, we're on the record. This is case 2355112. This is the state of Michigan. This is Jalil Muhammad. Muhammad is charged with 1 count of assault with a dangerous weapon, felonious assault. Today's name is examination appearances.
Lieutenant Cricker on behalf of the people, P 86282.
Good morning, Judge. Leno with NDS P 83424. Appearing on behalf of Mr. Muhammad, who is present in the courtroom. Mr. Muhammad, will you please state your name to the judge?
My name is Jalil Muhammad.
Good morning to everybody. Are both parties ready to proceed?
People are not, Your Honor. We've had no contact with the complaining witness.
Judge, commencement is dismissed without prejudice.
Okay, the time is now 9:44. The exam is set for 9:30. People are not ready to proceed, so I will dismiss without question.
Thank you, Judge.
You're welcome. Wrong record, shouldn't be too long for this forum.
Thank you, Judge. Zero, zero.
Oh, yes, to let Robert know that his person.
Yes,
Supposed to be another case. Go from there. Okay, we're on the record, this is people of the state of Michigan versus Jeremiah Bennett, 2355560. Mr. Bennett is charged with one count of robbery unarmed, saying they set for a probable cause conference appearance.
Alexander Kirker on behalf of the people, P 86282.
And there is no attorney present for Mr. Bennett, nor is Mr. Bennett present. I have a register of actions here, shows that Mr. Bennett received on February 16th of this year, a lower bond of $50,000 personal with a tether. So he is out on bond and was notified of his next court date today at 8:30. And he has not called the court or checked in. It's now 9:49. Is there a motion for the people?
The people will vote for a case to be issued.
I will issue a case, this will be personal for $1,000. We're on. Mr. Jefferson,
Yes,
morning.
good morning. How you doing?
Fine, how are you?
Pretty good.
Do you have a traffic matter today?
Pardon me?
Do you have a traffic matter today?
No, I have a rental thing today.
Ah, okay. You're in, this is the felony courtroom, so you should be in courtroom 436 with my brother, Adam Sabree.
Oh, okay. All right. I just know they had your name, so I knew you was my last judge.
Yeah, so it's my brother.
Okay.
436.
Thank you.
You're welcome. Have a good day.
You too.
Attorney Hayes, good morning.
Good morning, Your Honor. How are you?
I'm fine. How are you doing?
I'm doing okay. I just wanted to check in on Monday with Eddie Flint.
I've been checking the mailbox every day. I have not received the writ.
Okay, I'm not sure. I'm not sure what happened. My our support staff, or the one who completed everything, has been out this week with family illness. So I haven't had an opportunity to speak with her in terms of what's happening. I guess at this point, then I'm not going to worry about witnesses for Monday, and we'll figure it out if that's where we stand.
Yes. So for me signing the writ, can it be scanned over or do you need an original signature?
Your Honor, I'll bring it to you. Whatever's easiest. I have to be there Monday either way, or downtown either way. And not that, we're not in court regularly. So as soon as I can have it drawn up again, or I can just bring a copy of it. If you can sign it, I'll make sure we get it out with a new date whenever that works.
So no witnesses.
It's probably the easiest thing is if, pardon me?
I'm sorry, go ahead.
No, I said that's probably the easiest thing is if I just hand deliver it and, watch you sign it, and we'll know where it is.
Well, it's 100 years in time.
Yeah.
Okay.
Okay, I will let the attorney know, Mr. Harris know, and we can go from there.
Okay, thank you for checking in.
Yeah, thank you, Your Honor. Appreciate it.
All right, have a good weekend.
You too.
That's crazy. And you've been checking the mailbox every day, right? It's like waiting for. To the people of the state of Michigan versus Mackay, Eric Mayor Blight, 2355241. Mr. Blight is charged with 1 count of police officer fleeing 4th-degree vehicle code with a felony commission motor vehicle adult advisory. They set for a preliminary examination appearances.
Examiner Kirk on behalf of the people, P86282.
And good morning, Your Honor. Good morning, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428, on behalf of Mr. Blight. Mr. Blight, could you please state your name for the court?
Kyle Blood.
Good morning. All right, are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
None for the people, Your Honor.
Just ask that sequestration be enforced.
Okay, so there's no one in the gallery, and only staff and attorneys and a defendant present in the courtroom. If there's anyone on Zoom who may be a witness to this case, you are to log off at this time. Anything else? Preliminary?
Nothing from the defense.
Okay. Attorney, you can call your first witness.
At this time, the people call Officer Jacob Sorrell.
First up, you come to the next.
Yes, ma'am.
I'm sorry, right here. Whenever you're ready.
Good morning. Could you please restate your name for the record?
My name is Officer Jacob Sorrell.
And are you currently employed?
Yes,
Where are you currently employed?
Detroit Police Department, 5th Precinct.
And in what capacity are you employed?
I'm a police officer.
And how long have you been employed as a police officer?
Just over 2 months.
Were you employed as a police officer on January 19th, 2023?
I was.
Did you in fact work on that date?
I did.
Were you by yourself or with a partner?
I was with the partner that day.
And what is your partner's name?
Officer Caitlin Patrick Davidson.
Were you on foot patrol or in a scout car?
I was in a fully marked scout car.
Can you describe what you mean by fully marked?
Well, it's a white vehicle with the word police written in large print on both sides of the vehicle.
And did your duties as a police officer take you to an area at or near Chandler Park Drive and Whittier Street?
They did.
Is that in the city of Detroit?
Yes.
County of Wayne?
Yes.
And what brought you to that area?
We were on routine patrol.
And did anything happen while you were on this routine patrol?
Yes, we observed a metallic blue Dodge Charger traveling at a high rate of speed.
And do you know the speed limit of the road that you were on?
I believe it's 35.
And for clarification, what road was this? Were you on when you observed the vehicle?
It was on East Outer Drive.
And what did you do when you saw this vehicle traveling at a high rate of speed?
My partner attempted to stop the vehicle by initiating her emergency lights and pulling directly behind the vehicle in question.
And how close was your partner behind this vehicle?
I don't recall exactly.
Was it right behind the vehicle?
It was probably, as I recall, about 100 feet.
Did you have your lights on?
We did.
Was the siren on?
No.
And what happened when you attempted to initiate the traffic stop?
Upon initiating our emergency lights, we observed the vehicle accelerate away from us and disregard 2 red traffic control signals.
And were you able to obtain a license plate for this vehicle?
We did. At the time, we observed a partial license plate of Edward, of the letters E and U. And then the numbers 16 after that license plate, but as it was accelerating away, we didn't catch the entire plate at that time.
And what happened after you saw the vehicle disregard to traffic?
So we slowed down. We didn't pursue the vehicle any further, but we did issue a description over the radio of the vehicle that we saw.
And what did this description include?
It included the color of the vehicle, the make of the vehicle, the model of the vehicle, as well as the partial license plate description that we had picked out when we saw the vehicle, as well as the direction of travel the vehicle was traveling.
And when did you last see this vehicle?
you explain what you mean by that?
During this initial pursuit of the vehicle, when did you last see it? What was the last description you gave for the vehicle setting?
I don't recall.
And did you see this vehicle again?
We did.
And when was that?
That was probably about 4 minutes after attempt the initial traffic stop. When another vehicle, another officer from our precinct had spotted the vehicle based on our description and stopped the vehicle.
Objection, Your Honor, to speculation. Why that other car stopped the vehicle, he was not present, so he can't speak as to why the car was stopped.
Did another officer stop the vehicle based off of the description?
Yes.
I'm gonna allow that. It's the description on the radio. And he's stating, okay, fine. You know what? Actually, I'm going to sustain it. Can you rephrase the question?
Yes. When did you next see the vehicle?
On a residential street, which I don't recall, and the vehicle was stopped by our partners, another officer, another patrol vehicle from our precinct.
And did you make that scene?
I did.
Hello?
And what did you observe when you made that scene?
I'm sorry?
What did you observe when you made that scene?
We observed the driver of the vehicle detained.
Objection, Your Honor, lack of foundation, just ask that we establish how Officer Sorrell knows that it's the driver of the vehicle. I don't think that there's been any indication from that initial interaction that he would have seen anything. So if we can just get some foundation on that before he testifies that he knew it was the driver of the car.
Yeah, response.
Acknowledge, Your Honor. You saw an individual detained at the scene.
Right, we were advised by the other patrol officers that had stopped the vehicle, that the person they detained was driving the vehicle that they had stopped.
You know, I would at this point object to hearsay, Your Honor.
We can just limit it to his observations of the scene.
Okay, it would be hearsay for the officer to state with another officer. Observations were said.
What did you observe when you made this scene?
Well, we observed a young black male in handcuffs, detained by our partners. And the vehicle that we had described based on the color, the make, model, and the license plate that we observed.
And could you once again give that description of the vehicle?
Yes, it was a metallic blue Dodge Charger bearing the license plate Edward Nora Union. And then 1-6 in the last part, which I believe is Edward Nora Union 1662.
And do you see the individual who was detained in the courtroom today?
I do.
Could you please point out that individual and identify the article of clothing they're wearing?
Yes, a red button, or I'm sorry, a white button down.
Your Honor, let the record reflect the identification of the defendant.
This witness here. So.
And no further questions.
Yes, Your Honor. Good morning, Officer Sorrell. How are you doing?
Morning, I'm well. How are you?
Doing well, thank you. On January 19th, 2023, you have been on the force for about a month.
That's correct.
And as you were on patrol, were you driver's side, passenger side?
I was passenger side of the vehicle.
So would that mean you're responsible for doing clean searches with that computer that's in the squad car?
Yes.
Did you run a lean search in this case?
Eventually we did. But at the initial time of the conversation, well, that we attempted the traffic stop.
Okay. So in terms of what would have been the basis for the stop, it wouldn't have been anything dealing with registration or insurance or plates, because lien was at that time.
That's correct.
So the basis, the sole basis was the speed of the vehicle, as you testified to.
That's correct.
Now, you're on beat, or on patrol, I should say, and it's your job while you're on patrol to stop vehicles that you have reasonable suspicion to stop, right?
That's correct.
But it's late at night when you initially see that Charger in front of you, right?
That's correct.
There weren't any other cars to stop on the road.
I don't recall.
Was it busy? Were there many cars, few cars, one or two cars?
I wasn't busy.
And you had stated that the Dodge Charger was speeding, and at some point your partner attempted to stop the car, but officer, isn't it true that your squad car was going just about the same speed as that Charger in front of you for at least 30 seconds?
Not as I recall. As I recall.
Your scout car is equipped with a dash cam, correct?
It is.
And you'd be familiar with that dash cam footage if I showed it to you?
Yes.
Your Honor, at this time, permission to approach the what we marked fence A for identification purposes.
Yeah.
Playing the fence A starting at second 0. And I just want you to watch silently and I'll pause it and then I'll speak through it. Is this the scout car footage from the incident?
I believe so.
So and stopped at, for the record, second 26. So for at least 20 to 30 seconds, officer, the car that you're in is going about the same speed as the car that's in front of you, correct?
It appears from this footage that the Department of Patrol was actually closing this turn.
So you in fact going faster than that car?
Yes.
But not by much.
No.
And the car never passed you on either side. As far as we can see in this video, it always started in front of you.
As far as we.
Thank you, officer. And you mentioned that the car had ran those red lights, but you do recall that the Charger was put on its brake lights as it approached the stoplight, correct? You don't recall? Would the video from the dash cam refresh your recollection?
Possibly.
May I approach again, Your Honor? Thank you. For the record, claim starting at second 23. So, officer, just gonna ask again, did the charger activate its brake lights before you attempted to initiate the stop?
Can you repeat your question?
Did the Dodge Charger initiate its brake lights before you attempted to initiate the stop?
It's, I can't recall from that video at which point we attempted to initiate the stop by activating our.
But you did, but you do recall that the car in front of you had its brake lights initiated at some point?
Yes.
And that was at some point in front of the stoplight?
And Attorney Roberts, can you state for the record when you stopped the video?
Yes, thank you. At second 34. Now, is there a specific protocol with Detroit Police Department if a traffic stop fails to be effective?
What do you mean fails to be effective?
So if you try to stop a car and you're not able to stop the car, is there some type of policy or protocol that you have to follow after that?
There is.
What is that?
That depends on the reason for our investigation of the traffic.
So let's connect the policy to this specific case. What would have been policy for this case?
Under the circumstances given in this case, the policy is that given that the violation that we attempted to initiate the stop for, which was vehicle speed, if a traffic stop fails, that we discontinue a pursuit of that.
Is it policy to treat people in that car that is not stopped as armed and dangerous?
Can you expand on that question?
So is it DPD policy to treat occupants in a vehicle that is not stopped, the policy to treat those occupants as armed and dangerous?
I don't know of a specific policy addressing whether we treat vehicle operators as armed and dangerous.
So
To
the best of your knowledge, then, is it discretionary?
There is a level of discretion.
In this particular case, did you observe any evidence of a weapon?
No.
And during that first encounter with the vehicle, you did not see the driver.
That's right.
So when you get to the scene for that second encounter, you just see a young black man in handcuffs, correct?
And the vehicle is also there described by my partner over here.
But to be clear, that's the first time you've seen this particular.
I'm sorry.
That's the first time you are seeing this particular man is when he's in handcuffs. Nothing further. Thank you.
Nothing, none from the people, Your Honor.
I just have one question.
Yes, ma'am.
You said the location was at Chandler Park and Whittier. Driving the vehicle.
It was.
And where did you also say 4 minutes after you initially saw the vehicle, you saw the vehicle again when the defense was in hand, right?
Approximately.
What location were you at?
I don't know.
Okay. Any questions based on that?
None from the people, Your Honor.
None from the defense, Your Honor.
Thank you. Any other witnesses?
Yes, Your Honor. At this time, the people from the officer, Marie Mitchell.
I do.
Please restate your name for the record.
Police Officer Nari Mitchell.
And are you currently employed?
Yes,
Where are you currently employed?
the Detroit Police Department's Fifth Precinct
And in what capacity are you employed?
as a police officer.
How long have you been employed as a police officer?
3 years.
Were you employed as a police officer on January 19th, 2023?
Yes, sir.
Did you in fact work on that date?
I did.
Were you on foot patrol or in a scout car?
In a scout car,
Is it a fully marked or semi-marked scout car?
fully marked.
And did your duties as a police officer take you to an area at or near Harper Avenue and Guilford Street?
Yes,
And what did that, is that in the city of Detroit,
yes,
County of Wayne?
yes.
And what brought you to that area?
I was on routine patrol.
And did anything happen while you were on this routine patrol?
I heard a unit call out that they had a Dodge Charger
We
fleet
jumped
jumped
on, Your Honor,
over the radio.
to hearsay.
It's not an offer for the truth of the matter, sir. It's offer for the effect on the listener. He's receiving a police call.
It's already placed on the record. The call was made for a blue charge.
I understand that, Your Honor, just asked that in terms of making the nexus, there does have to be some admissible nexus. And if we're saying that the basis is hearsay, which is that they received a call, it is going for the truth of the matter asserted that in fact there was a call out. Otherwise, there would be no effect.
It is hearsay. However, receiving the call and responding is admissible, what the officer said.
And what did you do after receiving this?
The vehicle was last seen northbound on Cashew. I stood by at Harper and
Objection, Your
Guilford.
Honor, I'm sorry to hearsay and speculation as to where the vehicle was last seen. He can't speak to that. He has no personal knowledge of where the vehicle was last seen. He can speak to when he did see the vehicle. But as per your prior ruling, the content of whatever's on that call is inadmissible. And he can't speculate as to where the vehicle might have been before he saw it.
Just again, it's not off for the truth of the So it's an officer responding to the dispatch call over the radio.
If we can, if you can narrow it down to what Officer Mitchell observed.
What did you observe on this routine patrol?
I observed the vehicle matching the description of one that was wanted, hopefully in lieu.
Objection again, Your Honor. I understand that he stopped the vehicle. That's perfectly reasonable. He cannot say, based off of his own personal knowledge, that that vehicle had been seen by someone else. That is coming in through inadmissible hearsay or through speculation.
So he didn't say what the vehicle, the description was. He's doing his job. We have to have some foundation as to why he's there. So he's saying he's responding to the call, and based off of the description he received, he's now moving forward. So.
Yes, sir. As long as there's a limiting instruction that is not being offered for the truth of the matter, that's fine. I just don't want things to be stated on the record that are inherently speculative and based off of hearsay.
Okay, I believe what he said is fine so far.
And I just wanted to offer just so that we understand why the officer was stopping this vehicle. So can you give us the description of the vehicle that you observed?
It's a Dodge Charger.
Did you recall the license plate?
I don't recall the plate.
Would reviewing your report refresh your recollection?
Yes.
And approach, John.
Yeah.
Do you recall the license plate?
Edward Nora Union 1662. I'm sorry, ENU.
And what happened after you observed this vehicle?
So I observed the vehicle traveling eastbound on Hartford from Guilford. I turned out onto Hartford behind the vehicle, keeping an eye on it from a distance.
And when you say keeping an eye on it, were you following the vehicle?
Yes, I was following the vehicle. I didn't want to initiate a traffic stop on it because my pursuit policy doesn't allow me to chase. So I was waiting for the vehicle to stop.
And how long did you follow the vehicle?
I followed the vehicle until it came to a stop. Well, I followed the vehicle to Chester and Canyon where it made a turn and then deactivated the lights on the vehicle. And then I continued to follow the vehicle until it parked on Canyon and Lanoux.
And what?
You deactivated the lights at Canyon and Chester?
At Canyon and Chester, the Dodge Charger deactivated the lights on their vehicle. And then I deactivated my lights and stayed back a little distance, waiting to see where see where it went. Every once in a while, I'd see it hit its brake lights, so I still knew where the vehicle was.
And what happened when the vehicle came to a stop?
When the vehicle came to a stop, I positioned myself behind another parked vehicle, one car between us, and waited for the driver to exit the vehicle.
And did you observe the driver exit the vehicle?
I did.
And do you see the individual in the courtroom today who exited the vehicle?
I do.
Could you please point out that individual that's by article of clothing?
A white t-shirt.
Your Honor, let the record reflect the identification of the defendant.
So reflected.
And what happened after you observed the defendant exit the vehicle?
I observed him walk to the trunk, at which point I pulled my police vehicle up and exited, detaining the individual.
And no further questions, Your Honor.
Ross?
Yes, Your Honor. Good morning, Officer Mitchell. How are you doing?
Good morning, how are you?
Good morning, thank you. You mentioned that your pursuit policy does not allow you to chase vehicles, correct?
My pursuit policy only allows me to chase for certain things, and fleeing and eluding is not one of them.
So in this case, you were not able to chase.
Correct.
And at certain points, did the vehicle come in and out of view? You mentioned that you were following some ways behind the vehicle.
Yes, but I never lost sight of the vehicle.
Does your policy state that any occupants in a vehicle suspected of imminent looting are to be considered armed and dangerous? Is that part of DPD policy?
No policy that I'm aware of, no.
So it's
Not that I'm
based,
aware of.
thank you. So it's based on officer discretion.
Yes,
Now, in this case, when you activated your lights, the individual was already outside of the car.
correct.
And based off of that observation, did you see any weapons on this person?
No,
Did you think the person was armed?
there's no way for me to know if he was armed.
So you decided to arm yourself, correct?
I was already armed.
Well, specifically, you took your police issued handgun out of its holster and you pointed it at the individual.
I never required a target, but I did draw my handgun out of my holster, yes.
And you approached while the gun was drawn, correct?
Correct, I covered the vehicle and then observed my partner detain him, told him not to move.
Your partner also had her gun drawn,
Correct,
and you both approached the individual.
correct. I held cover at the car because I didn't know if there was any other occupants in the vehicle that could pose a threat to my partner or I. They did just flee from the police. So until he was secured and the vehicle was cleared and ensuring that no one else was in there, yes, our weapons were out.
And the moment the lights went on, this individual put their hands up, correct?
Correct, he was giving orders to us.
And if someone is putting their hands up, is it policy to threaten to shoot the person?
Is it policy? No.
If you remember your partner shouting to this individual, if you drop your hands, you'll regret it, correct?
I don't recall hearing that.
There was a body cam on both you and your partner at the time,
Correct.
and you activated that body, correct?
Yes.
You'd be familiar with that footage if I showed it to you?
Yes.
Permission to approach with what will be labeled defense B for identification purposes.
Yes.
For the record, starting defense B at second 0, I'm just gonna play a couple seconds off muted. And just let me know if you're familiar.
Am I watching this thing?
Just to familiarize, if this is in fact your video, I can't give any statements before you say it. Playing defense B starting at second 38. So Officer Mitchell, your partner said, if you drop your hands for any reason, you're going to regret it, correct?
Correct.
And by regret it, what do you think she meant?
Well, I can't speak for Officer Aliyah.
She had a gun pointed at the individual, correct?
I don't know if she regarded target with her weapon.
She had her gun drawn, correct?
Correct.
And she was approaching that individual, correct?
Correct.
Nothing further, Your Honor.
Right.
Nothing further, Your Honor.
Thank you.
None for the people, Your Honor.
Any for defense?
None for defense, Your Honor, thank you.
Clerk, are you ready?
At this time, the people have moved to bind over on count one, police officer fleeing 4th degree. As we heard from the first witness, the officer observed a vehicle traveling at a high rate of speed. They're able to get a description of the vehicle, which is a blue metallic Dodge Charger, and partial license plates. At this time, officers did activate their lights, in a fully marked scout car, and pursued the vehicle long enough to watch it travel away from the scout car through two traffic lights. And were not able to effect a stop pursuant to DPD policy or civil infraction. Officers are not allowed to pursue a vehicle that fails to stop. However, 4 minutes later, they were able to make the scene where another scout car, who, based on the description of a blue metallic Charger with a partial license plate, had followed this vehicle. Scout, at this instance, observed the defendants exit from the driver's seats and detain the defendants. And then the other scout car, who initially had tried to make the stop, made the scene, identified the vehicle. And so people believe that they had the probable cause and for those documents.
If you put your hands down for any reason, you're going to regret it. Your Honor, I just want to sit with those words for a moment, because when we talk about proper police conduct, police policy, when we're talking about two armed individuals approaching an unarmed black man who has his hands up, it calls into question the reasonableness of the stop. It calls into question the reasonableness of the officer's actions. And it frankly calls into the question the interest of the court. I understand that there is an allegation, and really the only allegation in terms of what is the basis for the stop is that this car is going too fast on a road. Just query, Your Honor, that the scout car that was following that car for 20, 30 seconds is going the same speed. I don't think it takes 20 or 30 seconds to catch up to a vehicle if you're trying to initiate a stop. I think what you did see is that when the stoplights were in front of that Dodge Charger, the vehicle initiated its brake lights, as you heard from Officer Sorrell. That's when they decided to stop the car, because there aren't many other cars on the road. It's not busy. It's nighttime. They're on beat. It's their job to stop cars. If this is the only car that they can find, I guess this is going to be the car that gets stopped. I think we all know what happened around 1 a.m. and 2 a.m. in the city of Detroit. The issue, Your Honor, is that everything else, including the decision to stop the car, is based off of discretion, and that discretion is grossly unreasonable. I can't imagine having to be Mr. Blythe's mother, looking at that video, seeing her son put his arms up, seeing her son have two guns drawn in his direction, even though there's no evidence of weapons in this case, no evidence of firearms. For an officer to tell a young black man who's about to be handcuffed, you're gonna regret it if you put your hands down. You know, I'm just gonna say it simply, why do you think black people sometimes run from the cops? Because they do not want to be shot, they do not want to be brutalized. And sometimes that fear is justified. I think in this case, at first blush, I'm arguing, and I think it's clear based off of the video that I don't think there's a basis for saying speed is a reason for a stop. If the squad car is going the same speed, is it do as I say, not as I do? But secondly, even if we were to accept that, the entire basis of fleeing and eluding is that officers are doing their lawful duty, and in executing their lawful duty, someone attempts to escape. I can't imagine what would be lawful about drawing a gun on an unarmed black man. I get it. Police officers' jobs are difficult. I understand that. But to traumatize young black men in this way, and to bind this over, and to act like this is acceptable behavior from police officers who are sworn to protect and serve people, and to say that because someone allegedly ran a light or was allegedly speeding, that gives police officers the right to draw their guns and to threaten to shoot the person. Let's be real. We know what regret means in a situation like this. In the interest of justice, because I don't find that there is a true reasonable basis or suspicion to stop the car in the first place, I'd ask that this case. Thank you, Your Honor.
Your Honor, just simply that we did hear a basis for the stop. We did hear from the Officer Sorrell that the vehicle was traveling at a high rate of speed. They tried to initiate a stop. The vehicle ignored scout car's lights, ignored two traffic lights. So we would once again ask them to be found over.
Okay, I am not going to recite the facts that we all heard. So the testimony from both officers is that the defendant was traveling at a high rate of speed based on their observation and did run two traffic lights, which is the basis for the stop. As both officers discussed or testified to, the policy of the police department is not to chase for several reasons, which we won't get into. But the first officer, Officer Sorrell, identified the vehicle as a metallic Dodge Challenger driving at a high rate and stated that the license plate was EMU16 from the initial observation, and then saw the vehicle again 4 minutes later and was able to get the rest of the license plate and identify the defendant 4 minutes after once he was detained. And that the vehicle was a fully marked vehicle. They activated their lights to stop or to attempt to stop the defendant. Officer Mitchell then testified also that they were in a marked car, same vehicle. They were partners or vehicle at the same time. And that Officer Mitchell testified to traveling eastbound on Harbor and waited for the defendant to stop, and that the defendant deactivated his lights in that same blue metallic Charger. It eventually stopped. As we saw in the video, the defendant stepped out of his car with his hands up, and contradictory to what Officer Mitchell stated at the beginning, that he did not draw his weapon on the defendant. The video shows that he did. Now, that happened after the initial attempt to stop the defendant. So I'll go through the elements for fourth degree in alluding. First, that a police officer with a uniform and performing his or her lawful duty, and that each vehicle driven by the officer was identified as the law enforcement. I believe that element has been met. Second, that the defendant was driving a motor vehicle, yes, a blue Charger. Third, that the officer ordered the defendant to stop the vehicle, and ordering can include activating police lights without audio. So that element has been met. And fourth, that the defendant knew of the order based off of the stopping and going, the activating from deactivating the lights and traveling at a high rate of speed and running two traffic lights. Infers that the defendant didn't know that he was being apprehended by the police. Fifth, that the defendant refused to obey the order by trying to flee or avoid being caught. As I just stated, based off of the behavior that officers testified to from the driver, the defendant, that he refused to obey the order. Now, I know there was something mentioned of the nexus between the person driving the vehicle and the person who will stop, which is the defendant. That would be a question of fact for the prior fact. As a testimony here that 4 minutes after Officer Sorrell observed that blue Dodge Challenger, or was it Challenger or Charger? I have Charger, excuse me. 4 minutes later, Officer Sorrell then observed the defendant step out of the vehicle. Next thing, Officer Mitchell's testimony. Part of it can be deemed incredible based off of the video versus what he testified to before the video was shown. And as we know that the trial fact can take all, some or none of a witness's testimony, that will also be something for the trial fact to determine. And Attorney Roberts, I am quite aware of the issues of people, Black people in particular, who fear the police. Unfortunately, that is not an offense to this crime, and the crime did happen before the guns being drawn. And I'm not stating that the police were right or wrong, or that they were right by how they apprehended the defendant afterwards. Also, as you stated too, the discretion, the police do have enormous amounts of discretion and power. They make the decision whether to pursue someone or not. Those are issues that are ongoing. I'm trying to stay focused on elements here, and I believe people have met their burden of proof, which is the probable cause standard for pleading and alluding in court. So I will have you bound over to Mr. Blythe for a ring on the information date of March 10th at 9:00 a.m. at Frank Murphy Hall. We're off the record. Okay, I have been trying to message you all while we were in exam. Nobody has responded. I'll start with Mr. Bennett. Is Mr. Bennett present?
Yes, I'm right here.
And Attorney Mercier here for Mr. Bennett.
Okay, I issued a capias for Mr. Bennett. His case was at 8:30 today.
I actually came up there in person, but I didn't know that I wasn't supposed to come up there. Like the court officer could tell you that he saw me in person today. I actually came up there in person.
Okay, and we tried to call you, Attorney Mercier, twice this morning.
And I apologize, Your Honor, I was on another line over at the 7th floor House Counsel Frank Murphy.
Did you issue the capias? No. Okay, so it hasn't been put in the system yet, so you guys are both here. Well, I'll just call the case now.
Thank you, Your Honor.
You're welcome. 2355560, the people of the state of Michigan versus Jeremiah Bennett. Mr. Bennett is charged with 1 count of robbery unarmed, set for a probable cause conference today. Appearances?
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Attorney Daniel Mercier, P72620, representing defendant, Mr. Bennett. Mr. Bennett, please state your name for the.
Yes, Jeremiah Bennett.
Okay, and Attorney Mercier, do you have any discovery issues?
No discovery issues, Your Honor. I have received discovery. This time, though, we would be requesting an in-person exam to be set in front of Your Honor.
Okay, let's see here. I have earliest I have is March 7th. Moving forward, it's pretty open.
March 7th, is there anything a little bit further out, Your Honor? Of course, we'd waive any time limitations. I have a hearing that day.
How about March 13th?
That will work, Your Honor. March 13th.
Okay.
Thank you.
So let's do, can you do 10:30?
10:30 would be great.
Okay. So Mr. Bennett, that means in person, just like you did today,
Yes.
on March 13th at 10:30 for your preliminary examination, okay?
Yes. Excuse me, Your Honor. Could I I'm on a GPS tether, and the power where I'm tethered to there's no power in the whole area at all.
Okay, I understand that.
And
Let's see.
but I'm listed
We have
to
part
be
of the
on.
order, Your Honor, that the tether restriction be removed.
So I'm going to remove it until the power issue is no longer, it's no longer a power issue. So for the, let's see, I don't know when that's going to be. Let me see.
I'm currently at my mom's house right now. I'm not where I'm tethered to, but I'm only here because I have Wi-Fi and.
Okay, so really the question is, do you want to stay at your mother's house until you have power back at your house? Mr. Bennett, you're on mute.
Can you hear me now?
Yes.
Yes. Once I spoke to the property manager where I live, and she said that she spoke to DTE, and they said it could be a couple of days or it could take a week. So I honestly don't know how long it's going to be. But everyone in the whole like there's no power in the whole area.
Mr. Bennett.
Yes.
I'm asking you a question. I understand there are a lot of people without power. Do you want me to let the tether unit know that your address has changed during the power outage to your mother's house?
Yes, please.
So I will put down for the next week that you will be at your mother's house because of a power outage. Does that work for you?
Yes.
Okay, I will send that order over today.
Thank you very much, Your Honor.
You're welcome. Anything else?
Nothing further on behalf of the defense.
Okay, you have a good day. Attorney Lamb, are you ready?
Yeah.
Good morning first, I'm sorry.
I'm sorry, good morning. What did Attorney Roberts do? No. Yeah, okay. Yeah, is that PTC?
He all right? Because he doesn't want to case
Right.
this time. Mr. Bennett, I need the address to your mother's house.
Say that again, ma'am.
I need the address where you're staying now. Mr. Bennett, do you have an address to where you're staying? If you don't know it, just have the person who knows to say it on the record so we can move on, please.
Yeah, could you give my sister
Absolutely. I am not calling your sister to get an address. This is you asking for an adjustment of your bond. I'm in the middle of docket 3, 4 things to hold. Do you have an address or not?
Until your power.
Okay.
You're not
Okay.
standing.
Yes. The address is 6863 Drake Street, and that's just until the power is back on at my area. I mean, at my place.
I know, I'm the one writing the order. Is it Detroit, Michigan?
Can you hear me?
Yes.
Yes, that's well, when you Google it, it says Hamtramck, but it's I think
Y'all, that's an argument. Now, let me get figured out when I'm in here. Something.
Did you hear me, ma'am?
Yes, what's the zip code?
The zip code is 48238, I believe. That
Can you close that door for me?
what's the zip code? 48238?
48212.
48212.
I'll put on the order for 1 week. You are staying at that house until your power is restored. Anything else? Sir?
Okay. Thank you, Your Honor.
Welcome. So the gentleman with the black or the blue and white striped shirt, can you unmute your device and state your name, please? Oh, that's Mr. Hill. Everybody's late today. Mr. Hill, can you unmute your device, please, and state your name?
Robert Charles Hill Jr.
Mr. Hill, why are you so late?
Actually, I couldn't get into the Zoom because I didn't have the actual app downloaded on my phone, and I had to put money on my card so I can download the app. I had someone actually going to do it because I'm on GPS Teller.
What does the teller have to do with logging in the Zoom?
I could not log into the Zoom because I didn't have money on my card to download the actual app. I don't know why I didn't download, but when I put money on the card, it downloaded. I couldn't tell you.
But what does that have to do with the teller?
I'm on house arrest. I cannot leave the house.
App is free, Mr. Hill.
Excuse me?
App is free.
Well, for some reason I couldn't download the app. When I put money on my card, I downloaded it. I couldn't tell you.
Okay, your attorney is here. We've been waiting. We have other stuff to take care of.
Okay. I haven't spoke to him yet.
Why is that?
I don't know. As soon as I got my phone out my property, I was sent a text message that was supposed to be like a link to log straight into the Zoom. But like I said, I couldn't log in because I didn't have the app downloaded and it never was no actual link. I called called down there the number that I received from you guys, and they gave me the case number to log in and I guess the Zoom meeting number. I'm not familiar with this app.
I don't have it. Oh, that's George. Okay. All right, this is people of the state of Michigan versus Robert Charles Hill. 2355476. Mr. Hill is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons involving firearm, count 3, domestic violence, count 4, malicious destruction of personal property less than 200. And this is the habitual second offense notice. Today's day set for a probable cause count. Appearances?
Alexander Kirk on behalf of the people, P 86282.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter Jonathan Roberts, P 86428, on behalf of Mr. Hill. Mr. Hill, could you please state your name for the court?
Robert Charles Hill Jr., sir.
Thank you.
Okay, any discovery issues?
We are still missing digital discovery, and I believe Mr. Kirker informed me this might be transferred to Judge King.
All right, I just noticed the BB chart. Just ask if we keep the case.
And in the interim, Your Honor, would you mind if I step out, log onto the Zoom so I can get Mr. Hill's contact information?
Yes.
Thank you.
I don't mind. Please.
Thank you. Mr. Hill, I'm gonna log on to the Zoom and then I'll request a breakout room so that we can talk for a second.
Okay.
So Mr. Hill, since you're
Yes.
under the Zoom, I want to talk to you and walk you through this. You will get an invitation to go into a breakout room. It joins so that you go into the room so you can have private conversation with your attorney, okay?
Okay then.
So pay attention to the screen. You're gonna get an invitation. You should get it right now.
Okay, thank you.
You're welcome. That's what we're gonna have to walk through. To ask the question. Yes, you. It's here. Thank you. Mr. Williams. Yes, Your Honor. Morning. Good morning. Okay, we are on the record with the people of the state of Michigan versus Marco Williams, 2355250. Mr. Williams is charged with count 1, robbery, armed, serious injury, count 2, assault, with intent to rob while armed, count 3, unlawful imprisonment, count 4, weapons felony firearms, as well as count 5 and 6, weapons felony firearms. Today's the day set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning again, Your Honor. Michael Lamb, P79816, appearing on behalf of Mr. Williams, who's also present. Ms. Williams, will you please state your full name for the record?
Yes, Marco Williams.
Good morning.
And Your Honor, this is the date and time set for the preliminary examination. I would acknowledge receipt of a paper discovery as well as media discovery. I have had the opportunity to review that discovery material with my client. I've also had the opportunity to advise my client of his rights to this preliminary examination, as well as the nature, scope, and purpose of an examination. At this time, though, Your Honor, we have deemed that we are going to waive the preliminary examination and have executed a written as such.
Okay, Mr. Williams, is that correct what your attorney stated?
Yes, Your Honor.
Okay, did anyone force you or threaten you to waive your exam today?
No, Your Honor.
Did anyone promise you anything in exchange for you waiving?
No, Your Honor.
Okay, and I just want to also place on the record that Mr. Williams is now receiving medical treatment that he needs, that he was not receiving while he was in Wayne County Jail. I don't know if Attorney Lamb, you were on the case.
I was, Your Honor. I drafted that motion. Thank you for allowing Mr. Williams to be released so that he could procure the necessary medical treatment.
And you weren't there for the bond redetermination hearing because those are done by another. I knew it was another attorney because Mr. Williams kept coming back.
Okay.
Advocate. I just want to put on the record that Mr. Williams hopefully doing better.
Yeah. Now, from what I can recall, I did make a bond argument at the last hearing, and I thought this matter may have been referred to pretrial services or whatever the agency is for Wayne County that makes those determinations.
It says here, I ordered a DSU report on January 23rd.
Okay, and has Your Honor received that report as of yet? Yay.
I have 3 reports down there, so I was hoping one would be. Let's see. Do you want to review it before I address it?
Please.
Okay, and just, Mr. Kirker, do you have an objection to the waiver?
No.
Okay. Let me see.
Or maybe, I'm sorry.
I can tell you right now, it says, as a matter of policy, pretrial services do not prepare investigation summaries or make bond recommendations when the defendant has already been granted a personal bond.
Okay.
So they did not.
Okay, so it's a mute point anyway, so, okay.
Yes.
Okay. I do have one other request though, Your Honor. So my client is on the tether and he desires to, deal with his grooming as it relates to his hair, some other kinds of appointments. He's not really able to do that at this time. Hey, I do my job, Your Honor. He's asking some leniency or some permissions to take care of his grooming. Yes, Your Honor.
Mr. Williams, are you serious right now?
Yes, Your Honor, because I just want to look presentable in court because I got my dreads cut off. My hair is real uneven. So I just don't want to be looking unpresentable. I want to look decent in the courtroom for you.
Now, Mr. Williams, 2 things. I appreciate you wanting to look presentable in court. And I also admire you advocate for yourself very well. I can continue to do that. But I'm not going to justify just so you get here, right? It's not enough to just based off of the seriousness of the charges. I was a little uncomfortable releasing you on bond, a personal bond, but based off of your injuries, I didn't want you to have any issues, blood clot, or any type of medical issues based off of me saying you can't get it. But the hair, that's a little bit much. So maybe at 3rd Circuit Court, you can address it again, and maybe there's another judge who will grant that, but I'm not going to judge for her.
understand.
Anything else?
Not at this time, Your Honor. Thank you for your explanation. I did communicate to Mr. Williams that that was a request that was unlikely to be granted. I just-
Mr. Williams, do you have someone come to your house and do it?
Your Honor, they're trying to charge $150 for a house haircut.
Oh, yeah. Okay. Well, they have YouTube. Somebody could probably help you. I don't know. But, you have to figure it out. Be creative.
Yes,
Okay?
ma'am. Thank you.
All right. Any turn anything?
Nothing.
Okay, so with that, I will have you bound over Mr. Williams to Third Circuit Court. Your arraignment on the information will be 2 weeks from today, since you're out of custody, March 10th at 9:00 a.m.
Yes, sir.
Frank Merville, we're on the record.
Well,
Okay, back on Mr. Hill. They want it? Oh, okay, so perfect timing. We're back on the record on Robert Hill. So the clerk did speak to Judge King, and it's gonna be transferred to Judge King.
okay.
Tony Roberts, you're on that case.
Yeah.
Okay,
This is his court.
we need to have Mr. Hill zoom into Judge King's courtroom as well as that Ms. Reynolds has to come down as well. Okay? Mr. Evans.
Yes, absolutely.
Thank you.
Madam Clerk, what's Judge King's courtroom number?
234. Yeah, second floor.
Thank you.
Problem.
Okay. I put partially held.
Judge King. Yeah, I'm sorry.
Mr. Hill, do you need the Zoom information
Yes,
for
ma'am.
Judge Kenny King?
Yes, I do.
Okay, let me know when you're ready to take it down.
I'm ready.
Okay, it's 360.
360.
I don't know it. Hold on one second. 234. That's 234. It's a regular.
Yeah.
Okay, 360-234.
Yes.
0000.
360-234-0000.
Correct. Go ahead and log on now. Your file is being transferred, and Attorney Roberts is heading down to that courtroom now.
All right, thank you.
Thank you all. Have a good weekend.
You too. To the person who has just logged on with the last 4 digits, 8773, can you identify yourself, please?
Thank you.
I didn't hear you. What's your name, sir?
Lamar Williams.
I issued a warrant, Mr. Williams. Your case is at 8:30 today.
I apologize. I didn't know how to do it, and I'm just learning how to. I didn't have access to a phone. I just got access to a phone. I apologize. It's my responsibility. I understand that, but I didn't have a phone.
Get your file. Have you talked to your attorney?
No, ma'am. I have not.
Have you ever talked to your attorney?
No, ma'am. I have not.
Okay. All right, so let's see here. I will, since it's not entered in the system yet, I will recall
I can't hear. You will recall my case, you say?
no, recall your warrant. So there's no warrant out for your arrest anymore.
Okay, thank you very much. So what I gotta do now?
I'm trying to figure it out because your attorney is gone. I'm not sure how to ensure that you're gonna come back to court, when you can come back based off your attorney schedule, so.
Okay, I can definitely come back after the first because I get my check on the first. I'm gonna buy my own telephone. Can you reschedule my court date, please?
I would like to, but I don't know if your attorney will be available. That's the problem.
Absolutely. That's what I'm trying to figure out. And I'm not really familiar with Zoom. I just called the number and got lucky. But I don't have a phone. I'm using a friend of mine, a stranger's phone. He allowed me to use it.
Okay.
But I'm buying my own phone.
March 3rd, come back.
Say that again?
March 3rd at 8:30 a.m.
March 3rd at 8:30 a.m.
Yes, and we'll call your attorney and let him know. Do you have a good phone number that I can provide to your attorney?
I don't have a telephone, ma'am. I'm sorry.
Whose number is this?
This is the strangest guy. This is a strange guy's phone. I don't even know him. I don't even know him. I don't have a phone at all. And I'm homeless.
So I need you to zoom in. So just zoom back in on March 3rd at 8:30, okay?
Yes, ma'am. Yes, ma'am. Thank you.
You're welcome. Have a good day. Lamar Williams. Hold on to that shot. Yeah. He's a strange person. Yeah. Not a strange.
So you took up the KPS?
Yeah.
And something in Monday?
Right, March 3rd.
Oh.
Yes.
Monday is the 27th.
Monday I have to do the bond determination here. Attorney Miller?
Yes, Your Honor.
My understanding, you are on Mr. Wilson's case?
DeAndre Wilson. Yes, Your Honor.
Okay, have you talked to him today at all?
Your Honor, I placed it in chat. The number I have for him is not valid. If the court has a good number, I'll reach out to him. If you could put it in chat, please.
We don't, he kept logging on, and I was trying to tell him he has an exam today, and to talk to his attorney, or call his attorney, to see whether or not he needs to be in person or not, so. He logged off, I don't have a number for him, I told him to stay on until the lawyer logged on, but he logged off.
Then I apologize, Your Honor. I didn't realize the day was getting away from me so fast. I didn't realize it was already past 11. I will be walking over to the court as soon as I finish at Frank Murphy.
Okay, we're about to hold an exam, so take your time.
Thank you.
Okay, you're welcome. Okay.
Aiden is here, Your Honor.
I thought that was too, right? Those are good. And this is what, we just talk. I'm trying to figure out too. Okay, we are on the record. The people of the state of Michigan versus Gregory Aaron Rockmore, who was defendant number 1, and Reginald Orlando Tarleton Jr., who was defendant number 2. Both defendants are charged with 1 count of robbery armed, and there's an habitual offender third offense notice for Mr. Aaron Rockmore, Gregory Aaron Rockmore. Today's day set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. I appear on behalf of Mr. Gregory Rockmore, who's president of the court. Mr. Rockmore, state your name for the record, please, loudly.
Gregory Aaron Rockmore.
Thank you.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Reginald Tarleton Jr., who's standing behind me.
Reginald Orlando Tarleton Jr.
Good morning. We were here, I believe 2 days ago. Yes, it was adjourned due to an issue with lineup. Attorney Brown, you see that lineup, correct?
Yes, ma'am.
Did you have an opportunity to discuss with your client anything that you needed to?
No, we're ready to go.
Ready to go? Are the people ready to go?
Yes, Your Honor.
Okay, any preliminary matters?
Nothing from the people.
None, Your Honor.
Okay, and for the record, there's no one in the courtroom other than attorneys, the defendant, staff. And I believe that's the officer in charge of the case? Okay, any objection to the officer in charge being present?
No, Your Honor.
No, Your Honor.
Okay, so anyone on YouTube watching the case, if you are a potential witness, you are to log off at this time. Mr. Kirker, you can call your first witness.
Your Honor, at this time, the people called Travis Farmer.
Okay, I'll swear you in, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? Have a seat right here in the chair, and make sure you speak up. Okay? And whenever you're ready.
Morning, could you please restate your name for the record?
Travis Barber.
And I want to take you back to the date of January 17th, 2023. Do you remember that day?
Yes.
Were you at or near the location of 14191 Burgess Street?
Yes.
Is that in the city of Detroit,
Yes.
county of Wayne?
Yes.
And what brought you to that location?
I work for the city of Detroit demolition department, and that was one of the houses on my list.
And what do you do as part of your job for the demolition department?
I take pictures of abandoned houses.
And was that what you were doing on this day?
Yes.
And something happen that brings you into court today?
Yes.
And what happened when you were at this?
Two individuals came out of the house across the street and they robbed me.
And
Just for the record, I asked that the witness be very specific about they, he, whatever, not just general.
Okay, Mr. P.
Your Honor, I was about to do the identification.
Okay.
And are those two individuals present in the courtroom today?
Yes.
Could you please point them out and identify an article of clothing that they're wearing?
They were both wearing green shirts.
And could you point to them? Your Honor, with the record reflect the identification of the defendants.
So reflective.
And you said the defendants approached you when you were at this location?
Yes.
What happened when the defendants approached you?
I was outside of my truck taking pictures of the house, and they came across the street from a different house, and they started yelling at me about not taking pictures of the property that they claimed to own.
And when you say they, are you referring to the defendants?
Yes, both of them.
And what happened after they asked you or told you not to take pictures?
I told them that I work for the city of Detroit demolition department, and that this house was the one that I was taking pictures of, was owned by the city, and that it was going to be torn down.
And did you have anything on that identified you as a city worker?
Yes, I had like a fluorescent vest on, along with my city of Detroit work badge.
Fluorescent what?
Vest.
Okay.
And what happened next?
I just told them that I work for the city and that this house is gonna be demoed, and that I didn't understand their claim that they owned it because it was on my list. It had a big yellow sign right on the house that said, this property will be demolished by the city of Detroit by this date or whatever. And they wouldn't take that for an answer. They just kept pressing me and saying, why are you here? You shouldn't be here. You need to leave. Comments like that.
And just again for clarification, when you say they, are you referring to the defendants?
Yes, both of them.
Again, I just want to ask that he be very specific about who he's talking. There's two different people, and you can't say that they.
Okay.
Actually, so what, whoever did what. You can do it.
I can't imagine the words were identical throughout the whole incident. So can you try, Mr. Berger, to specify, or have witness specify who said what?
Yes.
Whether if it was in unison, then specify that.
Yes, so if there are specific statements, could you identify which defendants made those statements, if possible?
They were both speaking kind of at the same time, very fast, but they both were giving the sort of same gist of the conversation of like, one would say, why are you here? You shouldn't be here. The other ones would say, you need to leave. You're not welcome here. Something along those lines. I can't definitively tell you who was saying what at the time. It's all very fast.
And did the interaction end after you explained what you were doing?
No.
What happened after?
They patted me down and took all the belongings out of my pockets, which would be my wallet and keys and my work phone. I'm sorry, not my wallet. My wallet was in the truck, but they took out my keys and my work phone.
Did one of the defendants specifically pat you down?
Yes.
Which defendant? It was the defendant on.
And for the record, that would be. Who did you point out?
My left, so individual.
With the shorter hair?
Shorter hair.
Mr. Carlton.
And what happened after they took these items? There was still a lot of dialogue going back and forth about how I shouldn't be there and that I need to leave and that they didn't appreciate my presence there. Around this time, the defendant on the left pulled out a pocket knife and put it like very close to my face. Told me that I should leave. And could you describe this knife? I remember the handle was black. It was metallic black. About how long was it? Anywhere from 3 to 5 inches. And you said where was this pointed at you? Right in my face, towards the tip of my nose. About how far from your face was the knife pointed at you? At times less than an inch. And you said at times, so how many times was the knife pointed at you? Over 3. And just for clarification, it is the defendants to my right who pointed the knife? Yes. For the record, that would be defendant's original policy. And how did you feel in this moment? I was extremely scared. I didn't know what was going to happen after that, especially with the knife in my face. I didn't know if I was going to say something wrong and they were going to stab me. I didn't know if I was just scared of my well-being. At one point, the defendant on the left, my left, said that he was going to drag me into the house that I was taking pictures of and he would cut me with the knife. And for the record, that was defendant Reginald Carlson. And so did you fear for your life? Yes. And did anything happen after this? They patted me down and took my keys and my work phone out.
I'm gonna object because, once again, he said they, he indicated already, I'm not trying to argue, okay, but he indicated that one person patted him down, and he said they. So would you be very specific?
The defendant on my left was the one who patted me down and took my items out of my pockets. At this time, all 3 of us walked over to my driver's side door of my truck. And the individual with my keys opened my truck and started going through all my belongings. The defendant on my right was talking to me about how this wasn't a robbery. This was just a toll that you have to pay for being on my block. And just for clarification, defendant Reginald Tarleton was the one in the truck, and defendant Gregory Rockwood was the one who made that statement? Yes, but they both went in my truck. Defendant on my right went into my truck as well after. And was anything taken from your truck? Yes. And what items were taken from the truck? I had 2 pocket knives in the center console. I had a jar of loose change that was taken. They took a phone charger. They took some candy, a pair of sunglasses, and they also took the hat off the top of my head. And did you ever get those items back? Yeah. And what happened after the defendants went through your truck? My wallet was in my truck because I don't like to take my wallet out of my vehicle because the neighborhood that I actually live in. They found my wallet and they found my, they were upset that there was no cash in here. They kept pressing me for money.
So, Attorney Brown, you
Thank you.
can you please specify who took your wallet or grabbed it?
The defendant on my left was the one who ended up finding my wallet in my truck.
That's defendant Reginald Thompson.
However, the defendant on my right also went through my wallet, was handed off.
So defendant Tarleton handed it to defendant Rockmore.
Yes.
What happened after that?
They found my asbestos contractor license ID with my home address on it. And they read my address out and they said that if I go to the police, they would come to my house and burn it down.
And were you afraid at this point?
Absolutely.
Who said that?
It was the defendant on the left. So,
And what happened after that statement was made?
there was a lot of dialogue going back and forth. They, sorry. Defendant on the left was making comments about how I didn't live in Detroit, how I lived in Martha Woods, and you could tell that seemed to upset him, that I was not in the city of Detroit. I was in the city of Detroit working, but not living. That upset him a lot. After this, the defendant on my right, they switched off and he went into my vehicle and started going through my things. He pulled out my backpack for work and he started going through that, but there was nothing of interest in him, the backpack, and that was eventually put back.
That'll be the person who's in to your right.
Yes.
And after the backpack was returned to the vehicle, what happens?
Again, there was a little bit of more dialogue from both defendants, and they told me that they weren't going to take anything else, but I needed to leave. They reiterated that I needed to not go to the police or tell anybody. If I did that, there would be consequences to me with my house and my family. And at that point, my truck keys were given back to me, and they were repeating my home address as I was leaving. And I took my keys and left.
And just to clarify, other than the keys or truck keys, was anything else returned?
No.
And roughly how long did this interaction last?
Roughly around 20 to 30 minutes.
And what did you do after you left?
The first thing that I did was I drove away I put a decent amount of distance in between myself and the situation. And because of the threats on calling the police, the first one that I called was my boss to tell him the whole situation, and then I drove back to my headquarters, which is the Department of Safety headquarters.
And did you eventually call the police?
I did not call the police, but once I arrived at my office, we went upstairs to there was some sort of police presence up there, and I filed an official report up there.
And just to clarify, did anybody have permission to take these items?
Absolutely not.
I have no further questions, Your Honor.
I just have a couple questions.
Yeah.
So you said, just clarification, somebody that you were the prosecutor said about things happening very fast, is that right?
Yeah.
But you said 20 or 30 minutes, not seconds, right?
Correct.
All right, so in 20, 30 minutes, you're having a discussion, right?
Yes.
And your discussion in the state of affairs of the city of Detroit meeting. I'm not trying to be sarcastic, but you're talking about whether or not you're supposed to be there or that sort of thing, right?
Yes.
Now, the individual on the right here never showed you any kind of weapon.
Correct.
That person never went into your pockets.
Correct.
Never patted you down.
Correct.
Okay. And your statement is that person was engaged in this discussion with you. All right. I think that's all. Thank you very much.
I have a couple of questions. You testified they took some type of pocket knife.
Yes.
At any point was the pocket knife given
Given as.
given to, handed over to?
No, it was taken directly out by center council. I never touched it in this interaction. There was two of them and I never took it either.
You stated that the knife that the defendant raised here on this side, Mr. Tarlington, pointed at you over 3 times, correct?
Yes.
Was there anything said during that time?
When he was pointing the knife at me?
Yes, when he supposedly pointed the knife at you.
Yes, there was a lot of dialogue. There was a comment that if I went to the police or if I went to the police, they would burn my house down. That was made with a knife in my face. The comment about how I would be dragged into the house that I was taking pictures of and gutted, that comment was made with the knife pointed in my face.
So it was Mr. Tarlington who's standing right here to my right, is the one who patted you down?
Yeah.
He's the one who had your keys?
Yes.
He's the initial one that went into your car?
He's the initial one, but not the only one.
So both defendants, both ones went into your car
Yes.
at separate times?
Separate time.
Okay.
I have nothing further.
Mr. Barber, you can step down and have a seat. You can step down and have a seat. You're on it.
Thank you.
Any other witnesses for the people?
None from the people.
Any witnesses for the defense?
None for Mr. Rockmore.
None for Mr. Tarlington, Your Honor. Okay, whenever you're ready.
At this time, the people to combine over on count 1 robbery crimes against both co-defendants, defendants Gregory Rockmore and defendant Reginald Tarleton. As we heard from the witness, he was there as part of his employment to investigate houses for potential demolition. At this point, he was approached by 2 individuals who he identified as both defendants. They engaged in a discussion in which statements were made that he was not wanted on his block, taking pictures of their home. And they tried to explain what he was doing there. Defendant Tarleton had pulled out a pocket knife, pointed it several times at the witness. Most of his face, times he said less than 1 inch from his face. His statement was made that he was dragging by defendant Tarleton. He was dragging him into the house and on him. The witness was then patted down by defendant Tarleton, in which his keys to his truck were taken. And from there, all three, the witness and both defendants, then went to the witness's truck, where the first defendant Tarleton went through the truck, and then defendant Rockmore went through the truck. At this point, several items were taken, including the hat that the witness was wearing, sunglasses, 2 pocket knives, phone charger, his wallet, which contained several IDs, a thing of loose change, and some candy. Out of the wallets, there was no cash, so that was returned. However, the IDs were taken, which had the witness's home address on it. Threats were made that if he went to the police, that they would burn his house down. As the witness stated, he feared for his life. Any reasonable person would have denied this point mentioned several times, and these statements were made. Eventually, he was able to get in his truck despite the items not being returned, other than his wallet without some of the IDs and his truck keys. He did file a police report. People believe that they have met the burden of probable cause.
I am not certain whether the Michigan Supreme Court has recognized the gentrification defense. But barring that, I'm going to object to the bind over without argument. Thank you, Your Honor.
Your Honor, I object to the bind over without argument.
Okay. Her testimony from Mr. Farber was trying to do his job, and his part to improve the city of Detroit, certain neighborhoods that have abandoned buildings. Testimony. I'm not gonna go through all of it, but very clear that defendant 1 and 2 work in unison to threaten and rob Mr. Park. Now, Mr. Charlton was the one who had begun, who had, I'm sorry, what did you say?
Pocket knife.
What did I say?
Gun.
I'm sorry. The pocket knife, excuse me. As well as patted the complaining witness down, Mr. Farber. And Mr. Farber said several times today and had to clarify who was saying what. But under the aiding and abetting theory, both defendant 1 and 2 committed in my, based on the testimony, armed robbery. Certain items were returned to the complaining witness, but his work phone, his pocket knives, his charger, loose change, as well as the hat was never returned. There were several threats that he would be gutted, as well as his house be burned down if he called the police. And just to put on the record, the aiding and abetting theory, which would apply to number 1, Mr. Rockmore, he filed to show that first, the alleged crime was actually committed by the defendant or someone else. Verdict has been met. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Here, Mr. Rockmore assisted Mr. Charlton in robbing and threatening Mr. Farber several times, as he did it for 20 to 30 minutes, going into his car and being very clear that he is not to call the police or report this crime. Third, that at that time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended the commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. And based off of the weapon being used and the threats that Mr. Tarleton were making, I think it's very clear that he was intending with Mr. Tarleton to I will have both defendants bound over for an arraignment on the information 1 week from today, which will be March 3rd at 9 and 5 p.m. for an arraignment on the information. Anything else on the record?
Thank you. I'd like to address the bond. I understand that both, that Mr. Charlton, forgive me, sir, I didn't catch your name. Mr. Rockmore has been bound over on, the charge. I would indicate he has some prior contact with criminal justice. He has very strong family support. I've been in contact with his mother a number of times. He is, in this instance, he's not possessor of a weapon. He's not the person who actually, had some direction with the weapon towards the complaint. I'd ask the court to consider reducing his bond to an amount where he can get out, and or adding a tender.
I guess the people, do you have a response?
I would ask the bond remain the same. This case is a very serious charges.
And Attorney Tucker, do you have a motion as well, or is it just?
No, Your Honor, I did, you did commission a DSU report in which, for Mr. Tarleton, in which they recommended 25,000, cash surety 10%. I am asking because Mr. Tarleton does not really have a criminal history. I asked that, because he's been in jail now for almost a month, probably has lost his job that he was being employed at. So he cannot afford that 10%. It's possible it can be something nominal or a personal bond with a tether.
Attorney Brown, did you have a specific request for bond?
I think the recommendation might have been, how much is it now, Judge?
Let's see.
$50,000 cash. Yeah, I would ask for it, reduction, say 15,000. Particularly given the nature of his participation, or alleged participation.
So the correct vote, Mr. Tarleton and Rockmore, either are employed or will likely have the job.
Not at the time.
Not at the time.
Not at the time.
I'm sorry, I should have finished one of
I have a couple more questions. So Mr. Tarleton and Mr. Rockmore, based off testimony, do they live together or were they living together?
No.
Okay.
No, Your Honor, Mr. Tarleton lives with his father and stepmother.
Okay. And Mr. Rockmore, does he have stable residence?
He does, but still a share. 14176 Burgess, where Mr. Rockmore lives.
And what about Mr. Tarleton?
Mr. Tarleton, 14791 Glenfield Street.
Yeah.
Detroit.
And Burgess in Detroit.
Yes, Burgess is in the right one. Right one, right? Right.
Okay, so the incident happened at 14191 Burgess. The only way I will adjust this bond is if they're a house arrest.
Yes. I mean, you give him a personal bond in the house arrest, that's fine.
Yes.
Now, we'll see what happens. Thank you.
So I will. The number is.
House arrest except for court appearances.
Correct, or any medical appointments. I'm trying to find the number, I don't see, okay, here it is. Mr. Charlton is 50,000 cash. So I'll just change that to a personal, 50,000. And for Mr. Rockmore, same thing, 50,000 cash, or just be personal. With house arrest, only to leave if you have to come to court or if you have medical appointments with proof that you have to go, as well as no contact with the plaintiff based off of what I heard. I don't think you know him, but no contact indirectly or directly with the plaintiff witness. And also the two of you, no contact with each other. Okay, anything else?
No, thank you very much, Judge.
Thank you very much.
Thank you.
You're welcome.
All right.
I'm sorry.
we are on the record with the people of the state of Michigan versus Alante Richardson, 2260761. Mr. Richardson is charged with the following. Count 1, carjacking. Count 2, weapons, felony firearm. Count 3, kidnapping. Count 4, weapons, felony firearm. Count 5, motor vehicle, unlawful driving away. Count 6, weapons, felony firearm. Count 7, weapons carrying concealed. Count 8, robbery armed. Count 9, weapons, felony firearm. Count 10, weapons, firearms, possession by a felon. Count 11, weapons, felony firearm. Count 12, weapons, ammunition, possession by a felon. Count 13, weapons, felony firearm. Count 14, police officer assaulting, resisting, and or obstructing. Count 15, weapons, felony firearm. This is a habitual offender second offense notice with a felony commission with motor vehicle adult advisory. Today is the day set for the preliminary examination. Appearances?
Good morning, Your Honor. Eric Decker. Afternoon. Good afternoon, Your Honor. Eric Decker, P8593 for the people.
And good afternoon, Your Honor. I'm Attorney John McWilliams, P17565. I believe this is generally known as the continuation of the preliminary examination since we were here yesterday. The court will recall under certain circumstances and conditions. By just way of explanation for the record, I might, Your Honor, this is a 16-count case, as the court is just illiterate stated. The fact of the matter is, the primary case in chief of this case has to do with carjacking and kidnapping. Yesterday, they did not have a victim witness for the primary cases. And I understand today that the primary witness or witnesses in this particular case have not appeared yet. I could be wrong. I have not seen any semblance of such persons. The fact of the matter is, there may be, and there are other charges. For example, resisting and opposing as a possible charge in this case. I would suggest that all of those officers for that presentation of that charge were here and available yesterday. They were not called, and the reason they were not called is because the primary witnesses or the primary aspects of these cases here was not here. And if she does not arrive here today, and if the court is not advised that she is here prepared to proceed, I will once again make motion to dismiss. Thank you.
And for the people who respond, Mr. Richardson, can you put your name on the record, please?
I'm Teddy Richardson.
Okay, and Mr. Decker, you're handling this case?
Yes, Your Honor. Okay, so a couple of points. First is that in the event that the complaining witness does not appear today, the people do intend to continue on the resisting, obstructing, and felon in possession charge. However, if we, what I can also say is that the victim in this case just called me 5 minutes ago and sounded like she was in a car and said that she will be here at 12:32. And in the event that she is here, I would like to go forward on count 1 and 2 as well.
You said 12:32?
She said 12:32, so 10 minutes.
That'd be 4 minutes. Oh, well, that clock is wrong.
Okay. Sorry, I was going off my cell phone.
No, it's right.
Yeah, she called my personal phone and I don't even know how she got the number. So like, I don't know. She said that she's going to be here, that her GPS said that she will be here at 12:32. I would ask that we wait that, and then if she doesn't show up by then we'd like to go forward with the resisting obstructing charge.
12:32.
Okay.
Of which we would oppose. For the reason that I said, resisting and opposing has to do with the primary case in which they could have been presentation of that yesterday with the continuing today. It's not the case. I say that their case in chief falls if they don't have the victim or victims in this case with regard to the primary charges, and the resisting and opposing charges would fall also.
I'm leaning to agree with that, but of course I have your argument.
I will respond, Your Honor. The resisting obstructing charge actually stems from, during the police investigation, there was an attempted stop. One of the officers turned on his lights in an attempt to pull over the car that the defendant was riding in. The defendant did not pull over, and in fact actually ran away from the lights that were from the lights. So
the vehicle that was part of this whole incident.
There was a police radio, yes, that said that to be on the lookout for a certain car. And then he said, and then when the officers saw that car, when they saw the car, they flicked the lights. Do we believe that the testimony will reveal? They flicked the lights, and the defendant who was driving the car then took off. So this would be just a situation where there was a traffic stop that was attempted, and that traffic stop was fled from.
Based off of.
Based off of.
Complaint from the complaining.
Well, based off of a radio saying, look out, a radio report saying, look out for this specific car.
Rooted from the incident that would be counted.
Yes.
Your Honor, I might indicate that resisting and opposing in my estimation is in fact a high misdemeanor, not felony, and it's only a tag along with regard to the other cases.
Resisting and obstructing is felony. I actually don't have a case on felony. Resisting, obstructing, and also felony possession.
Which count is resisting and obstructing?
I believe counts 5 through 9. Hold on, I think it's good. Hold on.
I don't see resisting and obstructing on here.
Actually, count 14, Your Honor.
Oh, there it is. I didn't read it. Okay, yes, count 14.
And Your Honor, with regard to the matter of felon possession, unless somebody is going to testify that they saw the in possession, that would take a witness. I don't believe they have a witness who would do that. Because
I don't have a witness here for the
Nor
complaining
do-
witness yet, so I think you, 1232, call the case, or we're going to move forward, and I will entertain your motion at that time.
Thank you.
I'm very clear and understand what the motion is, and people respond.
Thank you.
4 minutes. Handle, yeah. You ready on this?
Yes. What did you say? I'm sorry.
You're ready on this?
Yes. Yeah, it should be. Come here, whatever.
Okay, we are on the record. This is the people of the state of Michigan versus Elijah Romero Gaden, case 2355391. Mr. Gaden is charged with count 1, carjacking, and count 2, felony commission with motor vehicle adult advisory. Today they set for a preliminary examination. Appearances.
Alexander Berger on behalf of the people, 886-282.
Good afternoon, Your Honor, neighborhood fire services is right by that. 83355 here on behalf of Mr. Elijah Gaden, also present here with me. Mr. Gaden, can you please state your name for the record?
Sure, Elijah Romero Gator.
Good afternoon, everybody. Are both parties ready to proceed?
The people are not, Your Honor. The complaining witness was present, but it is my understanding after talking to the officer in charge and the victim's advocate that were out there that the complaining witness had a change of heart and did not want to prosecute. He has got his car back. So he's no longer present.
Anything from the defense?
Your Honor, the defense will move further to the at this time. And Your Honor, we would ask for that to be with prejudice.
Based off of what?
The witness's refusal to prosecute, I mean,
I know you haven't heard the testimony, but there was a lot of issues with his credibility, which we don't be on the reason why he didn't want to testify today, but, Your Honor, so we would just ask for it to be with prejudice, so that Mr. Egan doesn't have to go through this again.
I don't think that's the basis for which questions, but I would definitely dismiss without.
Thank you, Judge.
So, Mr. Gay, your case is being dismissed.
Thank you, ma'am. Well, Your Honor. Thank you.
You are welcome. I'll be compliment. Thank are you?
You there?
Okay. Oh, okay.
We're on the record on. Okay, this is a recall, the people of the state of Michigan versus Delonte Richardson, 2260761. I said that I would recall the case at 12:32 when the complaining witness said that she would be here. Mr. Decker is not present in the courtroom. I'm going to ask that Mr. Kirker stand in and put an appearance on for the people.
Alexander Kirker on behalf of the people, P86282.
Attorney John McWilliams, P 17565, Your Honor.
Ms. Richardson.
I'll say Richardson.
Okay. As you stated, Attorney McWilliams, from yesterday, this was adjourned because the complaining witness decided not to show up, even though she stated she wanted to prosecute. I asked the officer charged to personally or to subpoena the complaining witness to be here at 11:30 today for the exam. The time is now 12:36. called the case about 10 minutes ago, and Mr. Decker said that the complaining witness will be here by 12:32. We have not heard from her. I am at this time going to go ahead and dismiss this case without prejudice as the complaining witness has.
Thank you, Your Honor. That's on my motion. Thank you.
Okay, let me finish. The complaining witness has not shown interest in showing up to testify, in my opinion, or move forward with this case.
Thank you.
Thank you. Right.